Morning, and to some of us, good afternoon. Thank you very much for taking the time out of your busy schedule to join us today for our discussion on the newly enacted Pension Protections Act, which provides for enhanced protections for pensions in insolvency. While I introduce myself and our speakers today, please take a moment to review the information presently shown on your screen about any technical issues you may experience during our presentation. My name is Jessica Cameron, and I am a partner in Fasken's Insolvency and Restructuring Group located in our Calgary office. I will be your moderator for today's discussion. It's my pleasure to introduce our distinguished panelists to you. We have Michael Wolpert, a partner in Fasken's Pensions and Benefits Group, who splits his time between our Calgary and Toronto office. Michael is a recognized leader in the area of pension and benefits reorganizations, as well as advisor on the governance and administration of both private and public sector pension plans. He is a director of the Association of Canadian Pension Management, providing thought leadership on retirement income system policy and advocacy on behalf of Canadian plan sponsors and administrators. Next, I'm pleased to introduce Aubrey Kauffman, a partner in Fasken's Insolvency and Restructuring Group in Toronto. Aubrey is a distinguished and highly seasoned litigator and advisor in the area of insolvency and restructuring, advising a variety of stakeholders, including debtors, creditors, court officers, and directors and officers in many high-profile insolvency proceedings. A fellow of the prestigious Insolvency Institute of Canada, Aubrey is also an adjunct professor of law at Osgoode Hall Law School, where he teaches the bankruptcy and insolvency course. And last, but certainly not least, we have Gabrielle Motuz, a partner in Fasken's Banking and Finance Group, here with me in Calgary. Gabrielle is a well-respected and trusted advisor to senior counsel and clients with respect to both domestic and multi-jurisdictional syndicated and bilateral lending transactions of all kinds. Welcome to our panel members and to all of you who are here with us today to talk about the newly enacted Pension Protection Act, which elevates pension priorities in insolvency proceedings. Insolvency is all about priorities. By definition, insolvency means that there's not enough money to go around, so any funds go to competing creditors in order of legal priorities, and any remaining funds after that are shared by unsecured creditors on a pari passu basis, which is usually not a great place to be. In an insolvency, pensioners and pension plans can be vulnerable. Presently, certain pension shortfalls do enjoy protections in insolvency through certain super priorities, but those priorities are limited. The efficacy and priority of those protections has been relatively settled law for the past few years. The Pension Protection Act will radically alter that priority landscape. Today, we're going to address what that is going to look like and the potential consequences of the implementation of the Act. Michael will first address a brief pension primer, followed by a discussion by Aubrey of the present state of pension priorities in insolvency and what those priorities are going to look like in a post-Pension Protections Act world. Gabrielle will then address what these enhanced pension protections mean for lenders and borrowers alike. And finally, we will go back to Michael for a discussion of employer options to address the amendments and anticipated consequences. We will hopefully have time for questions at the end of today's presentations. So if you do have any questions, I would invite you to submit them in the Q&A chat box, and we will do our best to address them. Without further ado, I will turn it over to Michael.
Thank you, Jessica. We have the next slide, please. So as Jessica mentioned, I'm going to do a small pension primer, and I've indicated that it's just for today only because pension plans are very complex and multifaceted. We could easily spend the entire webinar talking about pension plans, but from one standpoint, I think today's session is really an insolvency and bankruptcy presentation that just happens to have pension plans as the context. So it's important to understand the pension plans that are affected by Bill C-228 and why the bill has such an impact But that's the extent to which this primer will go, just enough information to give you a basic sense of how the bill operates from a pension perspective. Next, please. So first off, what is a pension plan? At a very basic level, a pension plan is a vehicle to provide lifetime income to individuals following retirement. That's the sort of the starting point for pension plans. They're voluntary in the workplace, subject to collective bargaining constraints. And registered pension plans must meet numerous legislated minimum standards, including minimum funding requirements, and also if they wish to take advantage of the Income Tax Act, advantages of having a plan, they have to meet Income Tax Act maximum standards as well. There are a variety of other types of retirement savings plans, such as supplementary plans, RSPs, and so on, that are not subject to pension minimum standards legislation in the general sense. Next slide, please. So we are going to be talking a lot about defined benefit plans because they're the sort of the main focus of the concerns with this bill. And it's important just to have just a basic understanding of the difference between these types of plans and other plans. So briefly, a defined benefit plan is a plan where the retirement benefits a member receives are defined or otherwise fixed. They're set out in the plan text, and it might be a formula such as you may have seen 2% of final average earnings times the number of years of credited service or something along those lines. The funding investment risks are typically sit with the employer, and pensions are often paid directly from the plan. So again, it's the benefits that are defined and set out and promised. Whereas in a defined contribution plan, which you've no doubt heard about, contributions made to the plan rather than the level of benefits received are what is defined. So the contributions, might be a percentage of pay typically by the employer and by the employees in some cases are set out. In many DC plans, employees are responsible for investing their account balances, not always, but in many cases. And the account balances of retirement are typically transferred out of the plan to another retirement vehicle, such as an annuity. So that's kind of the basic difference, but we're going to be focusing on defined benefit plans for the purposes of today's discussion. Next slide, please. So who are the players? Very briefly and at a high level, the starting point is the sponsor or the employer. They establish the plan, they set the plan terms, the plan design, the formula. They have the right to terminate the plan and amend it, and they also make the contributions to the plan. In a private sector single employer plan, the sponsor is also the administrator in most cases. And what does the administrator do? Well, the administrator is responsible for ensuring, for example, that contributions are made to the plan when required, for investing those contributions, for communicating with plan members and others. They appoint and oversee service providers and so on. And then we have, of course, the members. In some cases, not always, but we have unions, and depending on how the pension plan is incorporated into the collective agreement, they may have a smaller or bigger role with respect to the actual plan design, and maybe a subject of a question of bargaining. And lastly, we have the regulators, the provincial or federal pension regulators who enforce the minimum standards, and then the tax regulator, the Canada Revenue Agency. So next slide, please. So let's take a quick look at valuations and funding. And this is really at the heart of the issues that Bill C-228 has given rise to. So a defined benefit pension plan has to provide for, or the administrator has to ensure that actuarial valuation reports are prepared. And generally, it's every 3 years on a triennial basis, or 1 year if there are solvency concerns. It really depends on the jurisdiction, but usually if a plan is in some kind of funding trouble, or is below a certain threshold, the regulators or the legislation will require that valuations be done more frequently. And these reports have to be prepared in accordance with the legislation and the Canadian Institute of Actuaries standards. There are very strict rules for the preparation of these reports that effectively require the use of certain methodology and assumptions, and they limit the degree to which a plan sponsor can manipulate the results. And it's important to note that the valuation report measures the funded status of a registered DB pension plan as of the valuation date. And there are different types of valuations. There's going concern, which assumes the plan operates indefinitely. And then solvency, which assumes that the plan terminates on a valuation date, but possibly with adjustments. And lastly, and those are the first two are the ones that are typically required. And there have been a lot of changes in Canada and various jurisdictions with respect to funding and requirements with respect to solvency funding and so on. There's too much to talk about today, but the real focus is sort of the going concern versus the solvency funding. And thirdly, reports may address a wind-up valuation. They may include it, they may have to, but generally and that assumes the plan terminates on the actual valuation date. So there are often differences, and these are important as between solvency and wind-up, again, depending on the jurisdiction. For example, Ontario excludes certain things from or it makes adjustments in the case of their solvency reports. So let's go to the next slide, please. Now, for funding, there are two basic types of contributions that have to be made. And the contributions are determined by the actuarial report and what is recommended there. And that's also important for purposes of the employer's ability to deduct those contributions for tax purposes. So those two basic types are the normal cost or current service contributions. So these are the cost of new benefit accruals by members in the current year. And then where we get into some more interesting aspects of funding are the special payments. So these are payments made to fund the deficits. And going concern deficits must be amortized in, for example, 10 years or less. And for solvency, they have their own set of amortizations and deficits and special payments. Those deficits are typically amortized over 5 years. And the degree to which or the amount or the point at which those special payments are triggered varies by jurisdiction. In Ontario, for example, it's less than 85%. And these amortizations can be layered and they can accumulate over years. So you can have quite a few sort of levels of special payments going on for a given plan. Next slide, please. So let's take a quick look at pension priorities in insolvency. Next slide, please. And in corporate insolvencies, a DB pension plan, or in the context of a corporate insolvency, a DB plan, defined benefit plan, deficit can be one of the creditors making a claim on the corporation's assets. And prior to Bill C-228, generally defined benefit pension plan deficits were unsecured creditors in insolvency proceedings. But Bill C-228 has radically and fundamentally altered the priorities, and Aubrey's going to talk about those in greater detail in those regimes by granting a super priority status to unfunded pension obligations. So even if those plans have been funded in accordance with legislation, these priorities jump ahead. And as we'll see in the, I've got one more slide in between. If we could move to the next slide, please. So in terms of legislative history, it's been interesting. Over the years, I mean, quite a number of years, and certainly as long as I can remember, there have been numerous prior attempts at similar legislation by way of private member bills to create this type of super priority that we see in Bill C-228. And all of those bills in the past have been dismissed quickly for the reasons and the concerns that were raised in response to Bill C-228, its impact on the ability of corporations to borrow money and so on. But somehow this sort of gathered some legislative steam, and it was passed very quickly in the House of Commons. It was passed unanimously, I believe, November 23rd, 2022. And then in April 18th, 2023, it received third reading in the Senate, and then royal assent just a few days later on April 27th. And so there are some transitional provisions which allow, or intended to allow, employers to adjust to the new regime. There's sort of a 4-year transition period, but note that the Act, this transition period, applies to more to plans that are already in place as of the legislation. So any new defined benefit plans that might be created, for example, as a result of a transaction, a spinoff where the company is required to establish, say, a mirror defined benefit plan, those plans, as I understand, would be subject to the legislation immediately. So next slide, please. And just to give you a sense of how unique this legislation is, how rare, and I think other countries have understood the rationale for not having this type of legislation. There's only one other OECD country with a super priority of for pensions, and that happens to be South Korea. And now I'm going to turn it over to Aubrey to take you through a little more of the machinations and impact on the from an insolvency perspective.
I was being a good boy. I went on mute as I was told. So I thanked Michael for his presentation, and I was just starting with what my thought process was when I was going through this. And what I did is the first thing I did is I read the legislation, but then I sat down with each of our insolvency regimes and I worked my way through it. And I said, like, how is this going to affect things in a bankruptcy? How is this going to affect things in a CCAA restructuring or in a receivership? And some of the results, I think, were anticipated. Some of the results may not have been anticipated because I don't think that the legislature took account in great detail of professional advice with respect to the technicalities of these amendments. But let's jump into it and let's look at what the amendments actually are. And it's sort of been interesting drafting because the actual act is only 7 sections long. And what it does is it really, it doesn't change the mechanisms or protections that exist for pension liabilities. It just does one tinker, which is almost a definition change. And instead of providing in the various pieces of legislation where protection used to be for normal contributions, and as Michael indicated, a normal contribution is a type of contribution you make to a defined benefit plan, sort of in the ordinary course to take into account new members and the cost of the plan. But it did not include special contributions, and it did not include, except in certain odd circumstances, the wind-up deficiency. What they've now done is they've changed the definition, in essence, of what's covered by the protections to cover all 3 of those elements, not only the normal contributions, but also the special contributions and the wind-up deficiencies. So as you can see on the screen, the amendments are, as I said, very delicate. With respect to the BIA, with respect to proposals under the BIA, the little tinker that they did is it used to provide that you couldn't approve a proposal unless provision was made to pay arrears of normal contributions. Now you can't approve a proposal without approving normal contributions, special contributions, and wind-up deficiencies. We're going to talk about what the potential consequence of that could be. Similarly, the BIA was amended to provide that in a bankruptcy or in a receivership, there used to be a super priority for arrears of normal pension contributions. Now, by changing the definition, that super priority is now for normal contributions, special contributions, and wind-up deficiencies. And what's the consequence of that going to be? And lastly, the CCAA was amended, again, not by changing its structure, but simply changing two provisions of the CCAA. One provision said that you can't approve a plan of arrangement unless previously normal contributions will be paid. Now it's normal contributions, special, and deficiencies. And equally, and this is one that I think is a little bit sneakier, you can't have an interim sale of assets in the CCAA unless you've made provision for payment of all of these amounts. Next slide, please. So basically, in insolvency restructurings, we're now going to have to take into account all of pension liabilities, including wind-up deficiencies, if there will be one. And in most regimes, that's on a super priority basis, ranking ahead of secured creditors. And we'll come back to that. Next amendment, please. Next amendment. We don't need more amendments. Next slide. No, go back, please. Okay. So what I'm going to do is I'm going to talk first about what's the law now and what's the effect of the changes of the Pension Protection Act. So before 2009, there was very weak protection for pension liabilities. The Pension Benefit Act provides for deemed trust, a statutory lien and statutory charge, but those were reasonably limited. The priority over existing secured creditors was limited to accounts and inventory, and generally that priority could get defeated by structurally including a bankruptcy in a restructuring process and getting rid of those protections. So in 2009, there was a pretty radical change to the Bankruptcy and Insolvency Act, and two super priority protections were included for employees. The first super protection was for wages, and the second super protection was for pension arrears. And I'm going to juxtapose the two of them because, and these super priorities, by the way, exist in bankruptcy and exist in receivership. And what the 2009 amendments did is they said that with respect to arrears of normal pension contributions, normal only, the employee has a super priority ranking ahead of secured creditors, ranking only behind very limited other claimants, source deductions, 30-day goods claims, and unpaid wages. The super priority, basically it was like a GSA, General Security Agreement, is over all of the assets of the employer for an unlimited time back, and with no cap. If you juxtapose that to wages, the wage super priority that was given was for $2,000 per employee, was limited to current assets, and the look back period was 6 months. So when these amendments came in, and they were, I think, good policy, I think that pension beneficiaries deserve protection and are often stranded in insolvencies. But that was the policy decision made at the time. I can say at the time that the lending community was very nervous with respect to the pension super priority, because as opposed to the wages, where you knew that your maximum exposure was $2,000 per worker, the exposure for normal contributions was a bit unknown, but that number was was able to be de-risked. You could sort of figure it out. You could take reserves. The existing law also under the CCAA, there was no direct protection of pension obligations. There was an indirect protection, and the indirect protection was twofold. The first thing was that you couldn't get a plan of arrangement approved unless arrears of normal contributions were to be paid immediately or be provided for in the plan, or unless the employees and the regulator agreed to something else. Similarly, you couldn't do an interim sale of assets unless those the normal contributions at the time were dealt with. Next slide, please. So whereas before we were only dealing with protection for the deductions from wages of employees for their pension, but that makes sense, it's their money, and for arrears of normal contributions. Now, the landscape has changed radically because the protections are now provided to every type of pension exposure of the employer, normal contributions, special contributions, that could be a lot of money, and the wind-up deficiency, which is actually an unknowable number, because the wind-up deficiency depends upon what is the market doing with the pension investments at the time of the wind-up. So implications for secured creditors, well, there could be a prior ranking security, the pension super priority, that will rank ahead of your security in a bankruptcy, in a receivership, and we're going to see in CCAA the primary party with security now, or with leverage, may well be the pensioners or the unions, depending on your perspective. That's a good thing or a bad thing. I think this will give bankers significant heartburn. So now let's go back and look at these regimes and walk our way through some practical implications that I'm not so sure have occurred to the legislatures. Next slide, please. Okay, so let's look first at CCAA. So the first thing I thought about is in a CCAA proceeding, which is a restructuring, debtor in possession restructuring, we start the proceeding by getting an initial order. And in the initial order, if there's a pension, it is very typical that the court will suspend payment of special payments. It will typically provide for payment of normal contributions unless the cash flow absolutely doesn't permit it. Now, what we used to do is defer payment of the special contributions, and then in an ultimate plan, they could be compromised, or in a bankruptcy, any priority that they may have under the Pension Benefits Act could be eliminated. But now we have to think about if we can't get a plan approved without the special contributions being paid, and if we can't do an interim sale without the special contributions being paid, do we have to rethink that strategy of not paying normal or in particular special contributions? We'll see how that develops. Next. Another interesting thing that may occur is with interim financing or DIP financing. It's clear that the court can order a DIP financing charge which trumps the deemed trusts under the Pension Benefit Act, and therefore gives the interim financier a super priority ranking, not having to worry about pensions. But what's going to happen if there's a subsequent bankruptcy where we have one federal act, the CCAA, an order saying that the DIP charge trumps all other charges, and we have now possibly a super priority charge under the Bankruptcy Act, which grants security over all assets of the debtor in priority to everybody except for three people: source deductions, 30-day goods, and arrears of wages. What's going to happen between the clash of those two those two priorities? I don't know the answer. I don't know practically if it is a problem, but certainly I can see walking into a century services type situation where you have a contest between two federally regulated priorities. But next slide, please. Now let me get into the more obvious issues with respect to the CCAA. Right now, the CCAA says you can't approve a plan unless the plan provides for payment of normal contributions, or the pensioners agree with the approval of the regulator. But now, because of the amendment, the court can't sanction a plan unless normal contributions, special contributions, and if there's going to be a wind-up of the plan, any wind-up deficiency is taken into account. Now, that totally changes the leverage of the negotiation of the plan. It also is going to increase the involvement of the regulator, for example, FSRA, because the regulator is now going to have to look at those proposed contributions or those proposed amendments to an immediate payment and decide if the regulator will go along with it or not. So you can imagine the change now in the bargaining dynamic, where instead of special payments and wind-up deficiencies being matters that can be compromised and negotiated, now those must be dealt with upfront, or the plan can't get approved. Next slide, please. Another thing I stumbled on is most CCAAs don't end up in a restructuring of the business. Most CCAAs now end up with a sale of the business within the CCAA proceeding, and then either a bankruptcy to distribute the money or distribution of the monies in accordance with the plan. But there was always a provision in the section dealing with approval of interim sales saying that the court couldn't approve an interim sale unless it protected payment of normal contributions. I think that provision was often forgotten about, or in worst case, it only dealt with normal contributions, which typically were a manageable, arrears of normal contributions, which typically were a manageable number. But now, interestingly, if you read this literally, you can't do an interim sale of assets unless there's provision for immediate payment of normal contributions, special contributions. If there's a wind-up deficiency, probably the timing wouldn't be there. There wouldn't be one yet, but I don't know how that would work. But the interesting thing is, Section 36 doesn't have the same provision that Section 6 said, which is that subject to an agreement by the pensioners approved of by the regulator. So is that just a slip because of how they did the amendments? Will people read into that you can still get the agreement of the pensioners? Or is there going to be a real challenge now in doing interim sales? Next slide. I thought about BIA proposals. Basically, the same issues that arise in CCAA with respect to approval of plans and the court approving an interim sale will apply with BIA proposals. So we have the same problem there. Next slide. Okay, so the next thing I thought about is receiverships, because if you read the Pension Protection Act, it doesn't deal with receiverships at all. And typically, before these amendments, the protection in the BIA for pension arrears applied in a receivership. But again, that was only normal contributions, a number that you can get your arms around and deal with. With respect to Pension Benefit Act protections for other types of contributions, in a receivership, those could get defeated by putting the company into bankruptcy, and by the doctrine of paramountcy, those protections would go away. And in a receivership, there are two court-ordered protections that typically are involved. The first is a court-ordered protection of the fees of the receiver, and the second is a court-ordered protection of the borrowings of the receiver. And if you look at the language of the model orders of Ontario, the protection for the receiver, for its fees and for its borrowings, were always subject to that section in the BIA that created a charge for wages and for pension priorities, because the BIA says that the pension super priority is only subject to, I said, three things: source deductions, 30-day goods, and wages. And again, receivers would take on this mandate and lenders would lend, because the only thing they were behind were the normal contributions, and you could get your arms around that. But with the amendment of the BIA to include the protection for special contributions and wind-up deficiencies, I question in a scenario where you're being asked to be a receiver of a manufacturing company that has a pension that has either arrears of special payments and or will be in a deficiency when you wind it up. What are you supposed to do if you're a receiver and your protection for your fees ranks behind that? And similarly, if you're a lender to a receiver, what are you going to do if the loans to the receiver may be subject to arrears of special contributions and wind-up deficiencies? So very interesting. People, whenever legislation changes, run around typically saying the world is going to end. Typically, we figure out a way to avoid the world ending. But certainly, these amendments create issues which some are obvious and some less obvious. You have to work your way through how we do things now to see what the impact actually is going to be. With that, I'll turn it over to Michael. Oh no, I'm going to turn it over to Gabby.
Thanks, Aubrey. Hi, everyone. I'm going to speak a bit on the lender's perspective now. Implications of Bill C-228 on credit. We do not expect that there will be a noticeable disruption to the lending market from the implementation of Bill C-228, given the relatively small number of companies which have defined benefit pension plans. Investment grade entities that have defined benefit pension plans should not be materially impacted by Bill C-228. With non-investment grade companies and companies in the automotive, transportation, retail, and steel industries that do have defined benefit pension plans and existing credit facilities in place, there are likely already representations, warranties, and covenants built into the credit agreements, requiring the plans be fully funded at all times with events of default tied to any funding deficiencies. However, going forward, we would expect lenders to pay greater scrutiny to the pension liabilities given the increased risk of the defined benefit pension plans. Lender risk mitigation strategies. We would expect for non-investment grade borrowers some of the following matters to be addressed in the applicable credit agreements. Requirements to provide updated actuarial valuations on the defined benefit pension plan on an increasingly regular basis. More frequent reporting with regard to the funded status of the defined benefit pension plan. Events of default being triggered by funding deficiencies of the defined benefit pension plan in excess of a specified dollar threshold amount. For any credit facility that's tied to a borrowing base, we would expect that any defined benefit pension plan funding deficiencies would be deducted from the calculation of the borrowing base. And for corporations being required to make special payments to address funding deficiencies, we would expect lenders will require that those payments be made on an accelerated amortization basis. Finally, the implications on borrowers, I think, are pretty clear by now, but it's reasonable to expect that non-investment grade borrowers who have defined benefit pension plans will be subject to increased costs of borrowing, given their increased risk profile. And there's a potential that some companies with defined benefit pension plans may be considered unbankable. I think it's now over to Michael.
Thanks, Gabby. And the, some of these options are still obviously being considered, and in part because, as Aubrey indicated, this bill is only 7 sections. There are an awful lot of unknowns in it. The extent to which the act even applies, whether it extends to plans that aren't covered specifically under the federal pension legislation, which is the way it's the act is kind of set up as the federal legislation is kind of a go-to. And so plans like target benefit plans, jointly sponsored pension plans, how it's going to impact multi-employer pension plans in other jurisdictions. So an awful lot of unknowns. And it may be that some of these things are addressed in regulations at some point. We don't know, haven't seen anything yet. And certainly, Parliament was made aware of these various shortcomings, but none of them were addressed. And there are also unknowns in terms of the application of the funding rules to provincially regulated pension plans, for example. As Aubrey indicated, the federal rules apply the way or that the bill sort of imposes the federal funding rules on provincially regulated plans. And apart from any constitutional issues, there are big considerations because those funding rules differ. As I mentioned earlier, there are differences between solvency funding and wind-up funding and so on. And you could end up with a situation where the solvency deficit is actually far greater than the amount needed to actually fund the plan on wind-up. And this, depending on the plan, you could easily have a situation where there are hundreds of millions of dollars in difference that certainly lenders would be concerned with from a credit standpoint. So to that degree, there are a lot of unknowns, but basic options, sort of some of the obvious ones that we can focus on for purposes of today's discussion are things like converting the plan to defined contribution, to just take it out of the DB realm entirely. But that can be quite complex. It's very difficult in some cases to convert past service benefits. Conversion is a very time and cost intensive process. And you could end up with a situation, in fact, when many plans were converted back in the late 90s, early 2000s, where there's still a sort of a legacy DB provision. So the problem could take many, many years to disappear entirely, although you could sort of limit it on a go-forward basis. And of course, there are certainly HR considerations when you're doing something like that, in addition to sort of labor relations and other considerations. Some employers have chosen to join larger public sector pension plans that are offering turnkey participation for private sector employers. So they've created sort of a separate division, separate funding, a separate administration structure to allow smaller entities to simply convert or take their existing plan and sort of plonk it into the public sector plan, and they kind of do the rest. Some of the more notable plans that are doing that are CAT in Ontario, also OP Trust in the, I believe, sort of more the charitable sector, not-for-profit sector. So there are some options there. And other strategies might be to implement some type of de-risking strategy, such as an annuity purchase, to help immunize the plan against fluctuations in deficits. And, I mean, some of that is going on anyway because of certain financial circumstances, changes in interest rates. So certainly plans are de-risking in any event, but this may spur plan sponsors or to take that sort of move forward with those plans. Whether to the degree to which lenders will accept sort of those de-risking strategy is kind of a whether that will soften their approaches remains to be seen. And sort of lastly, the big hammer, I suppose, or the big choice would be to terminate the defined benefit plan entirely and implement some new type of retirement savings vehicle for employees. Whether it's a group RSP or something else that or a DC plan, but something else that simply doesn't involve the type of funding and give rise to the situations we've heard about today. Now, terminating a DB plan is also fairly time and cost intensive and is sort of a last resort. But the reality is in the private sector, DB plans have been declining for quite a number of years, partly because of the issues we had with solvency funding and the situations that arose when we had financial crises such as the dot-com bubble in 2008, and companies were faced in some cases with either continuing their pension plan or keeping their operations, or funding their pension plan or keeping their company alive. And so a lot of most pension plans now are really a financial function rather than an HR function, and cost is, or sort of the bottom line cost is really what drives things. So a lot of plan sponsors have simply gotten out of the defined benefit plan business, so to speak, and it's realistic to consider to assume that because of Bill C-228, that trend will continue significantly. So lastly, in a unionized environment, there's going to have to be a review of collective agreement, and negotiations with the union will be required in order to make any changes. I think that's a given, but certainly unions have been in Canada have been quite vocal in expressing their views for continuation of defined benefit plans, and I don't see any reason that wouldn't continue. So it may be a bit of a tug of war and a balance of interest for plan sponsors in dealing with employees and unions versus being able to borrow money the way they want to finance their operations. So that's it for me, and I'm going to hand it back to Jessica.
Thanks very much, Michael. So in the past, there have been a number of instances where employers, unions, representative council, members, and pension regulators have all worked together to restructure pension plans during CCAA proceedings to allow both the employer to emerge from creditor protection, but also maintain that pension plan. Stelco and Air Canada are good examples of these. As a result of the Pension Protections Act, pension plan deficits, as you've heard, must be funded before all other creditors get paid. There are concerns that this is going to stifle the creative and successful arrangements that have been implemented in the past. While unions and pensioners can agree to an alternative other than payment in full of the pension deficits, it certainly shifts the balance of power, as it were, around the negotiating table. And it gives them an effective veto over the restructuring plan where there are material pension liabilities. As Gabrielle discussed, there are also concerns that the Act may increase the cost of borrowing for for borrowers, I should say, where they have defined benefit pension plans. And with a 4-year implementation period for existing pension plans, we expect some defined benefit pension plans will be terminated entirely. Those are just our thoughts. There have been a few questions submitted by our audience throughout the presentation, so I will just turn to those and field them for our panel. So I think the first question that has come in, Aubrey, is in your ballywick, and it is, why would this legislation have been advanced in light of the decision in Indilex? What, if any, were the perceived shortcomings of Indilex? Aubrey?
Okay, that's a pretty easy question, because basically Indilex involved a contest between a debtor, a DIP financing charge, and the deemed trust under the Pension Benefits Act. And I would say there were 3 reasons why this legislation is a quantum leap different than the protection in Indilex. The first thing is, Indilex did push the envelope to say that the PBA deemed trust extended to wind-up deficiencies. But that was only the case if the plan was in wind-up before the CCAA proceeding commenced. So Indilex dealt with 2 pension plans. One was in wind-up, one wasn't in wind-up. The one that wasn't in wind-up didn't have the wind-up deficiency protected. That's the first thing. The second thing is, if you look at the Ontario Personal Property Security Act, the priority of this pension trust under the PBA was only with respect to an asset, a collateral category of accounts and inventory. So to the extent that the trust existed, it was limited. But the most important thing is, we used to use a trick of, at the end of a CCAA, putting the debtor company into bankruptcy. And because of the doctrine of paramountcy, you could do what we call a priority flip, or a priority inversion. And by virtue of the bankruptcy, for complicated legal reasons, all of a sudden now secured creditors ranked in priority to the pension deemed trust. So for those reasons, Indilex is not the greatest protection, and the Pension Benefit Act isn't the greatest protection. But these amendments that now incorporate into the BIA normal contributions, special contributions, and in some way wind-up deficiencies, it eliminates the doctrine of paramountcy as being relevant, because this is federal legislation to federal legislation. And it cements in those liabilities at a super priority level.
Thanks, Aubrey. Michael, the next question we have here, I will direct to you, and the question is anything being done to exclude jointly sponsored pension plans or management employee pension plans from the ambit of prescribed plans under the Pension Benefits Act?
Thanks, Jessica. I think it's actually probably a reference to multi-employer pension plans. As the map, and the short answer is I don't know. As I alluded to, certainly the way the Act has been, or Bill C-228 was constructed, and because of the types of plans that are currently referenced in the BIA and CCAA, it's likely that they're caught, even though it doesn't make any sense in either context, and certainly in a lot of jointly sponsored plans that may also be multi-employer plans, depending on the jurisdiction, how they're structured. I mean, they may be public sector plans where there's little likelihood of insolvency, but you could certainly have, say, a jointly sponsored pension plan with a single employer that could be at risk here. So there are an awful lot of unanswered questions. The bottom line, though, is we don't really know what's happening. I mean, if they presumably if they wanted to carve those out, which would make sense, it would have to be by by regulation. But a lot of those details and concerns were forcefully expressed both in Parliament and by way of written submissions and public appearances, and also in the Senate. And both levels of Parliament chose to ignore those concerns.
Which is unfortunate, but here we are. Next question in here, Gabrielle, is for you. I think you touched on this a bit during the presentation, but we have a question here about whether there's a way as a lender to mitigate the risk, ask for an actual actuarial report yearly, and make an assessment according to market.
Yeah, as I mentioned, we expect there's going to be a lot more information and reporting being required of a borrower with a defined benefit pension plan. There's going to be some thresholds for default on funding. Overall, I think the lenders will probably wait and see what happens with this bill and how it plays out. But they already protect themselves pretty well against any concerns with defined benefit pension plans to the extent that they exist in the market right now. But we can expect more of the same, more reporting, more events of default, that sort of thing.
Thanks, Gabby. We just have a few more questions I'll try and field here. Aubrey, this one relates to the extent of the super priority, and it asks, can we assume that all DB plans are included in the super priority if USA borrower?
Don't know. So just breaking that into pieces, I think that the legislation applies to regulated pension plans in Canada, provincial and federal. So I think and I may have to defer to Michael, but I would think that the insolvency legislation applies to Canadian plans if the fact that the sponsor is a U.S. entity may matter in terms of if you're going to sue the sponsor for these amounts, or with respect to assets of the sponsor that's going to be subject to the super priority security. Would the Canadian, for sure that the assets in Canada would be subject to the priority. You'd have to think about if you could use Canadian insolvency legislation that creates a charge, a super priority charge to chase the borrower's assets in the US. That you'd have to pay for the memo.
Right. Thanks, Aubrey. And just a question for you, Michael, about whether there's a difference between going concern deficiencies and wind-up deficiencies. So just a point of clarification.
Yeah, I mean, there are, and because of the way they're measured, the methods, the methodology and the assumptions, so it's going to vary by circumstance, but typically there will be a big difference between those two valuations. And sort of one of the crazy things here is that I think, as I noted earlier, you can have situations where the solvency deficiency or other deficiency actually exceeds the wind-up deficiency, and you could have absurd circumstances where pensioners might be getting or somehow entitled to more than, or the plan more than more money than is actually needed to fund the benefits for pensioners on wind-up. But bottom line, though, is that there is a significant difference between those valuations and how they're determined.
And let me just jump in because I'm looking at the legislation as Michael's talking. They don't talk about the wind-up deficiency. They talk about any amount required to liquidate any other unfunded liability or solvency deficiency of the fund. I don't think that that's pension language. So it's like, I'm not sure what any amount required to liquidate any other unfunded liability means. And I think that that's going to have to be like in Indelex, where the fight was, what does an accrued liability mean? I think people are going to have to fight about what exactly is the meaning of that broad word, any other unfunded liability.
Well, arguably, Aubrey, if I can just jump in, you could have a situation, say on a CCAA filing where valuation has to be done, arguably at that time, at the time of filing.
Yeah.
And so you would turn to presumably the federal legislation, if you had an Ontario plan, the federal legislation for the funding rules, for solvency rules, and then possibly to Ontario's rules for that other category, the other funding for funding on a wind-up basis. So I agree with you. It's completely unclear, doesn't make a lot of sense, but those things will just have to play out at some point, presumably.
It's unclear, it's uncertain. So we expect, there will be challenges to this and questions. If you do have further questions, please do reach out to us. We are happy to assist you as we can. That's unfortunately all the time we have today. Thank you again for taking the time to join us for our discussion on this. And we hope you take care.